Hello viewers, welcome to your favorite channel Rising Legal. Today in this private international law class, I am going to discussion an important topic, that is meaning, nature and scope of private international law. Viewers, before going to detailed discussion about this topic, at first we try to know that international law are classified into two categories, that is public international law and another is that private international law. Private international law is essentially a part of the municipal law of a state, and these private international law are applied where there is a conflict between the private person with the sovereign state. It is to be noted that although Grotius is considered as the father of the international law, but the term international law was in fact first defined by Sir Jeremy Bentham in 1780. So, private international law is a branch of legal services where the procedural rules of this are applied to determine which legal system and jurisdiction shall apply to a particular conflict between the private person and the sovereign state. Dicey calls it as a conflict of laws since it deals with rules regulating cases in which municipal laws of different states or nation come into conflict. Such conflicts may arise with regard to domicile, marriage, divorce, will, contract, etc. Hence, it is also called as a international municipal law. Now, viewers, I am going to define another important definition given by Pete Corbett. Pete Corbett is one of the famous writer of international law. He mentioned that private international law is the body of rules for determining question as to the selection of appropriate law in civil cases which present themselves for decision before the courts of one state or country but which involve a foreign element, that is, which affect foreign persons or foreign things or transaction that had been extended into wholly or partly in a foreign country. Now, viewers, I am going to the next page of this particular topic, that is functions of private international law. First function of private international law is that private international law is a law of different state and which concern mainly such matters between individual as fall at the same time under the jurisdiction of two or more states. For example, contract of sale or services between persons in different countries. Now, second functions is that private international law primarily concern itself mainly when there is a case having foreign element, whether the municipal court of the state can exercise jurisdiction over such cases. Second thing is that on account of foreign element, if the legal dispute is connected with different system of law, which of the system of law is to be applied, because private international law is not the same in all countries. There is no one system that can claim universal recognition. For example, if the English court decide that it possesses jurisdiction, then the further question as to the choice of law must be considered, that is, which system of law, English or foreign, must govern the case. The action before the English court, for instance, may concern a contract made or a tort committed abroad or the validity of a will made by a person who died domicile abroad. In each case, that part of English law which consists of private international law direct what legal system shall apply to a case, that is, to use a convenient expression, what system of internal law shall constitute the applicable law. So, viewers, English private international law, for instance, requires that the movable property of a British subject who dies intestate domicile in Italy shall be distributed according to Italian law. So, the function of private international law is complete when it has chosen the appropriate system of law. Its rules do not furnish a direct solution of the dispute. Now, viewers, next function of the private international law is that private international law are part of the internal law of the state concerned, and private international law differs from state to state. Now, another important function of the private international law is that private international law enacted mainly through legislation enacted by the legislature of different state. Another function, that is number 5, private international law does not at all confer absolute right. Now, viewers, I am going to discuss another phase of this topic, that is what are the scope of the private international law. Viewers, there are various scope of the private international law, and these are the scope, that is rules relating to the jurisdiction of the court. When we discuss in the scope of the private international law, basically these are actually came. First is that rules relating to the jurisdiction of the court, rules of choice of law, and the rules relating to recognition and enforcement of the foreign judgment and decree. So jurisdiction, viewers, actually is a very important actually factor to decide a matter of a particular court, and jurisdictional questions are to be the first issue to be debated before the courts of law. The procedural laws of every country specify the nature of jurisdiction that can be exercised by the local courts. Courts do not take in the jurisdiction unless the service of the summons could be made on the defendant. Now, jurisdictional question has two special significance in private international law, mainly in three reasons. First is that in certain circumstances, the court exercises jurisdiction even in the absence of the defendant. This power, which naturally is of greater significance in foreign than in the domestic cases. Second thing is that there are certain types of action, such as petition for divorce, where the mere presence of the defendant in the country does not render the court jurisdictionally competent. Third is that there is a separate regime of jurisdictional rule in the case of a defendant domicile, specifically defined sense in a member state of the European Community. Now, viewers, in the particular in jurisdictional matter, there is one famous case, that is Nachippa Chettiar versus CTA and CT Subranama Chettiar. This is the case in the year of 1960. It was held in that case that the Court of India have a no jurisdiction over immovable property situated in the foreign land. So it is one of the remarkable judgment that came in that particular case of Nachiappa Chettiar. Now, viewers, the second thing regarding scope of the private international law is that choice of law. Actually, when the court decide the jurisdiction, when any matter came to a particular court and the court actually decide the jurisdiction, then the next question came, that is the choice of law. So, upon a decision related to the existence of a court jurisdiction, the next question that arises in the choice of law, that means which law should be applied to the suit in question. To be more precise, does the law of the forum, as in the internal law, be applicable law, or should be a specific foreign laws become applicable? Now, viewers, regarding scope of law, that is scope of your private international law, the next important factor is the recognition of a foreign judgment. It is another important actually matter which the court or judges actually have to follow. Recognition of a foreign court decision is an important part of the rule structure under this domain of law. And it is an extreme importance to the disputant that they should be able to enforce the outcome of their dispute resolution procedure in the course of any country where the defendant's party has his asset located. So, viewers, this is our actually today's discussion in private international law. Hopefully, you understand this matter clearly. Lastly, I actually thankful to all our viewers who actually uh, watching our channel. Thank you very much.